there's ambiguity between what the words mean, the court should err on the side of a constitutional interpretation. So religious gatherings, just like public protests, are constitutionally protected behavior. So in my opinion, I'd argue that if there is any doubt left with, if that word private isn't clear enough, certainly the court should err on the side of not prohibiting constitutionally protected behavior.
Hatim Soos here for Rebel News, and last week I was very fortunate to be joined by Sarah Miller, who observed a landmark decision which effectively determined that the Chief Medical Officer of Health in Alberta, the orders under which many people were charged for protesting and gathering under a very specific window, do not actually apply to protesters in any way, shape, or form.
What we've seen previously, I think, by large, is people disagreeing with somebody's principles about, being an anti-lockdown person, the court disagreeing with that, and then deciding, well, because I disagree with your principles, you must be, guilty, or you must be at fault here, right? And that's not the same thing. We can disagree about principles and still apply the correct legal analysis. This morning, I think the correct legal analysis was applied.
Obviously, the language utilized within that decision and within that specific order discusses private gatherings, and the judge ruled effectively that protests are clearly not private social gatherings. Now, I'm very fortunate today to be joined by the lawyer from the Justice Center for Constitutional Freedoms, who is actually working directly on that case to get the facts of the case and to discuss his outlook on any potential precedent this may set and the impact that it may have on other cases, very high-profile cases, including the cases of Pastor Tim Stevens, Pastor Artur Pawlowski, and many others who were ticketed or even saw incarceration as a result of their activities surrounding COVID-19 protests. So, in just a moment now, I'm going to be joined by Justice Center for Constitutional Freedoms lawyer Hatim Kheir.
It has reasons and principles that will be applicable to other decisions made by judges in Alberta. You can kind of think of it as shades of gray, right? So it'll apply pretty strongly to anyone charged under the exact same order. And then kind of the next rung out from that, you can think of anyone who's charged with maybe other health orders that use that same language of private social gathering. And then from there, you can also think about, there might be differences in situations. So this was pretty clearly a public protest. There were hundreds of people there. It was advertised to the public. And then you can get into, is a church gathering public? I mean, my personal opinions, it probably is, but I'm sure there's lots of different fact situations out there.
Yeah, so given that you're working so closely on this case, were there orders prior to this that used that term private gathering? Or did the order continue to use that language moving forward? Not saying that this is sort of binding on judges, but just from your perspective, how many of the health orders use similar language, or could this theoretically be applied to? Many people are thinking it could be the entire range of orders going back some time and moving forward up until now for anyone who attended protests. Others suggesting it's more narrow. What's your sort of expert opinion on that?
I do know that the previous version of this order from November used the same language. I'm pretty sure they'd used pretty similar language, a bit previously and going forward. Though ultimately, interestingly, and this came up in the trial, is that in a later version of the public health orders, the government actually amended it to specifically create an exception for protests. Mm-hmm. And almost like the implication there is almost, well, this does capture protests, but we created an exception for it now, but previously there hadn't been one. So the Crown actually made that argument in the trial, but ultimately the judge rejected it, finding that rather what had happened is the province had come around and probably rightfully clarified what was going on in order to accept protests. But yeah, certainly for some of these earlier protests, especially around that sort of end of 2020 leading into 2021 period, I expect that pretty similar language was probably used throughout.
So then you mentioned that there is a particular in Alberta here, we did see with the case of Pastor Artur Pawlowski, Tim Stevens, James Coates, and a number of other churches as well, certainly, and other churches across Canada, that these, I think most people would probably agree that a church worship is not a private gathering, especially if everyone is welcome and they're public, and they're intended to be open to everybody. Not that this relates to this case directly, but in your sort of professional constitutional opinion, do you think that it's reasonable to hope or assume that if they're saying, well, a public protest is okay, public worship probably will not fall under the order as well? What's your opinion on that? I don't think there's been a ruling so far.
Yeah, to my knowledge, there hasn't been a ruling yet. In my opinion, the argument should absolutely be made. So thinking back to the words that Judge Dinkel actually used in this decision, what he ultimately came down to was the kind of the plain meaning of the word private. And what he said was that private means the public is excluded.
Yeah.
So if we take that quote and try to apply it to other situations, I would think that for most churches, that's probably true as well. The public isn't excluded, so it's not private. It's a little bit different, unlike something being held on public property in the middle of in front of City Hall, where hundreds of people can kind of walk right in and gather. A church at least has 4 walls, so maybe it's a little bit different. But I think if you come back to that core of what does the word private mean, I wouldn't think a church would apply. And one of the other arguments that we made in this trial was that when there's ambiguity, this is a legal principle when it comes to interpreting statutes. If there's ambiguity between what the words mean, the court should err on the side of a constitutional interpretation. So religious gatherings, just like public protests, are constitutionally protected behavior. So in my opinion, I'd argue that if there is any doubt left with, if that word private isn't clear enough, certainly the court should err on the side of not prohibiting constitutionally protected behavior.
Well, Hatim Kheir, thank you so much for the important work you're doing, and thanks for joining me for this update on this landmark ruling and some of the other work you're doing. We really appreciate it. And for everyone out there for tuning in, I want to thank you so very much. For Rebel News, I'm Adam Soos. It's certainly refreshing to have some positive news coming out of Alberta courts after a couple very rough years, which saw people's rights very much trampled. These landmark victories, this good news that we are seeing now, it didn't come out of nowhere. It is the result of lots of long-term hard work by these organizations, the Just Center for Constitutional Freedoms and the Democracy Fund. Another case where we had an incredible victory thanks to the efforts of the Democracy Fund and Chad Williamson of Williamson Law was the City of Calgary rescinding their injunction, which sought to stifle free speech, which sought to stifle protesting within the City of Calgary. Thanks to their efforts, the city dropped that injunction. If you want to be part of that victory, learn more about it, or contribute to those legal costs, you can do so at protestlawsuit.com.